Companies Act Section 174. Quorum for meetings of the board. 1. Definition and importance of quorum in board meetings. In order to ensure effective corporate governance and decision-making, the law mandates that every meeting of the board of directors must meet a minimum attendance requirement, known as the quorum. The quorum ensures that a sufficient number of directors participate in board meetings, making the decisions valid and representative of the company's leadership. 2. Minimum quorum requirement. According to Section 174(1) of the Companies Act, the quorum required for a valid meeting of the Board of Directors is 1/3 of the total strength of the board, or a minimum of 2 directors, whichever is higher. Additionally, participation of directors through video conferencing or other audiovisual means is permitted and will be counted for the purpose of forming a quorum, ensuring flexibility in board meetings. 3. Authority of continuing directors despite vacancies. Per Section 174(2), even if there are vacancies on the board, the remaining directors are permitted to act. However, their actions are limited in cases where the number of directors falls below the required quorum. In such cases, the continuing directors can only appoint additional directors to meet the required quorum, or call a general meeting of the company for appointing new directors. They are not allowed to conduct other business until the quorum requirement is met. 4. Quorum in case of interested directors. In situations where the number of interested directors who have a personal or financial interest in a matter under discussion, exceeds or is equal to 2/3 of the total strength of the board, Section 174(3) specifies that the quorum shall be formed by the remaining non-interested directors. A minimum of 2 non-interested directors must be present for a valid quorum. Definition of interested directors. For the purposes of this provision, an interested director is defined under Section 184(2) of the Act as any director who has a direct or indirect interest in a contract, arrangement, or transaction being discussed in the board meeting. 5. Adjournment of meetings due to lack of quorum. If a board meeting cannot be held due to a lack of quorum, Section 174(4) provides that the meeting shall be automatically adjourned to the same day, time, and place in the following week. If the rescheduled date falls on a national holiday, the meeting shall take place on the next working day at the same time and venue. This provision ensures that board decisions are not indefinitely postponed due to quorum-related issues and that the company's governance remains functional. 6. Additional explanatory provisions. To clarify certain numerical considerations, the following explanations are provided under Section 174. Fractions in numbers shall always be rounded up to the next whole number. For example, if 1/3 of the total strength is 3.3, the quorum required will be 4 directors. Total strength refers to the total number of directors excluding vacant positions. This means that if a company has a 10-member board but 2 positions are vacant, the total strength for quorum calculation will be 8 directors. 7. Legal implications of non-compliance. Failure to maintain quorum as required by Section 174 can lead to serious consequences, including invalidation of board decisions, making them legally unenforceable. Potential penalties for non-compliance, as stipulated in the Companies Act. For more details, contact us.